Namaskar, this is Akhilesh Bhargava again. Welcome to Tidbits on Business and Finance with me. Let me tell you a story of a harassed company director. A gentleman, an eminent professional, was on the board of directors of a company for just 10 days. He resigned thereafter. He was a director in a very professional capacity. He resigned immediately after that 10-day period. But to his rude shock, he was charged with various violations committed by the company. The violations related to non-filing of routine returns, forms and notices by the company with the registrar of companies. They were just routine civil violations. But what he got was a notice whereby he was dragged to a trial court on criminal charges. That was the year 2006. We are in 2018 today. Those cases have not even come up for hearing before this director. He continues to face the anxiety of a criminal punishment by a company on whose board he was for just 10 days, and that too for very unintentional, non-deliberate offences by way of non-filing of returns, forms and notices by the said company. A small civil violation suddenly faces a criminal action against a director of a company. And these are sections of the Companies Act under which lakhs of cases remain in trial courts undecided. The Companies Act, for some reason, provides that a criminal prosecution will take place of the company, its directors and its key persons in case of these minor offences related to non-filing of returns, non-filing of forms and non-filing of notices. It results in a lot of harassment, and this kind of frivolous litigation dragging company directors and company key personnel to courts for civil offences is a key irritant in ease of doing business in India. As I said, courts are clogged with lakhs of such cases. In fact, whenever the SFIO or any body like that undertakes an investigation of a company, you can be sure hundreds of such cases get filed with the trial court for violations which are of a civil nature, but the punishment is going to be of a criminal nature, and the hapless directors face the courts till years together before either the case comes up for hearing, and most of the times it is observed that the courts exonerate such directors. These kind of cases get dismissed primarily because the offences were not intentional. The offences did not really result in any unrich gain, unfair enrichment of these particular directors or the company personnel. And the courts, trial courts, rightly tend to dismiss most of these cases. The government has been conscious of this kind of frivolous litigation, and it has recently set up a high-powered committee under the Ministry of Corporate Affairs to review these sections and not criminalize civil offences, minor civil offences by companies, because this kind of a situation where a civil offence is given out a criminal prosecution is not only unfair and unreasonable, it is also not commensurate with the kind of offence that took place. The committee has just been appointed. I'm sure it will take a few months before the report comes, but it would be really heartening if we see that the Act is amended. These kind of minor violations, civil violations, are punished by way of a commensurate fine or a penalty, but the directors and the key officers of the company are not dragged to criminal courts. Something like this looks to be in the offing. If you look at, or if you recall, the Economic Survey 2018, it had specifically mentioned that the government is the biggest frivolous litigant in the country. Of course, that analysis in the Economic Survey was with reference to tax cases, wherein it was pointed out that the government is a major litigant, it tends to lose most of its cases, but yet it keeps filing tax cases and keeps losing most of them. And the underlying message or the underlying plea of that survey was, I think something needs to be done about it. The government seems to be conscious about it and is doing something about it. While on one hand, it has set up this committee for trying to reduce unwanted corporate frivolous litigation against the company and its directors. On the other, the CBDT has now announced regulations under which the kind of cases that are being filed in courts by the income tax department will come down. It has stipulated that cases will be filed before the Supreme Court only if and only the amount of tax involved is 1 crore and above. So if there is a case which has a tax impact of less than 1 crore, it will not go to the Supreme Court. A similar limit has been prescribed for cases filed in the high courts, and that limit is now 50 lakhs. Only if the tax amount involved is 50 lakhs and above will the department take you to the high court, and the limit set for tax tribunals is 20 lakhs. With this upward revision of limits, a significant amount of tax cases are expected to be withdrawn. The estimate is that 40% of tax cases are likely to be withdrawn by this upward revision of litigation limit set by the CBDT. I think it is a most welcome move. It is going to reduce litigation, it is going to improve the ease of doing business in India, and it is certainly going to be very efficient for businesses in the country. It is good to note that the government is conscious of frivolous litigation, and we hope that the committee set up in the case of the Companies Act comes up with measures whereby A, there is no criminal prosecution for civil violations, and the penalty or the fine prescribed is quite commensurate with the offence involved. This is Akhilesh Bhargava signing off till we meet again. Namaskar.